Yes, counsel. Good morning.
Good morning. May it please the court, my name is Sharon Devon, and I represent the defendant, Mr. Damian Gouse, in this matter. If I may, I will start with the question of sufficiency, as was addressed in the previous case, as far as the carrying of a firearm is concerned, and as far as firearm licensing scheme is concerned. And if I may, I will address what was previously raised by the justices here, is that the possession of a license or license to carry or an FID card, as was held in this court, is not an element of the crime per Powell. So if we were to follow that logic, we only need to look at the statute. When you look at the body of the statute, or the indictment for that matter, it simply reads possession of a firearm without an FID card or carrying a firearm without a license to carry. The exemptions, as this court had said, is part of the last paragraph of the statute. The enumerated exemptions are not part of the body of the statute. As it is, the statute reads that you are required, or it will be a crime if you have a firearm without an FID card or if you carry a firearm without a license. Therefore, it is our position, or my position, is that it was the intent of the legislature to make it an element of the crime. It's not an exemption. Now, if this court were to hold, and it has held in Powell, that no, it's not an element of the crime, then in a sense the court is saying the crime is carrying a firearm or possession of a firearm, which in its face is unconstitutional because the Second Amendment essentially protects against that right. So,
but we don't treat it as an element of the crime. I mean, we even tell police officers that possession of a gun is not enough. You can't arrest somebody just because you see him with a gun.
Exactly.
And then throw the burden. So it's not an element of the offense.
Which is what was held in Powell, and that's correct. And that's essentially Judge Zobel's problem with cases like Couture and Jones, saying if this is an element of the crime, if you are telling the police officers that just having a firearm is not a crime, and it's not enough for a probable cause or even a reasonable suspicion, then how can this court say that having a firearm without anything else is enough to pass muster as a reasonable doubt, beyond a reasonable doubt? And that, I believe, is what Judge Zobel is saying, is that, yes, it was in the context of a case of a co-venturer, but that was not the essence of her holding. The essence of her holding was that this court cannot jive the decision in Jones versus Couture, because in Couture, if you're saying just because somebody's carrying a firearm, the police officer does not have reasonable suspicion to even stop that individual, then how can you say in a context of a trial, then that is enough to pass muster for beyond the reasonable doubt standard, which is the highest standard we have. So if you look at it just from the perspective of excuse me, just from the perspective of looking at the indictment, very simply put, if you take that out of the element of the crime, then you're left with nothing else but possession of firearm or carrying of a firearm. And respectfully, this court can't do that because it's a constitutionally protected right. So as my prior counsel suggested in Harrington versus U.S., the court essentially says, and I quote, they say you cannot presume criminality from a constitutionally protected act.
But we treat insanity exactly the same way. It is an element in a sense. It's an element of murder, because you have to have the mens rea. You have to be competent to do it. But we don't require the Commonwealth to prove it in every case. We require the defendant to come forward with some evidence of insanity.
But and
once the defendant does that, the Commonwealth has to prove it beyond a reasonable doubt.
But I would suggest to the court that's a little bit different. The intent in every case has to be proven by the Commonwealth. So that is implicit. The intent to commit a crime has to be proven in every single case. As for mens rea, then it becomes, all right, now the defendant now saying, I did not have the intent VI being incompetent at the time. That puts it a little bit different context than in this particular case, where simply, as I suggested by my predecessor, the FRB, the Federal Records Bureau, it's just as easy to check for somebody who has a driver's license via the RMV as it is to check for somebody who has a firearm license via Federal Records Bureau. And As for the suggestion that would that be then burdensome to the Commonwealth because then they have to then they have to produce someone from the Records Bureau to testify, no, they don't have to, because it's just as the Records Bureau is a regularly conducted course of business. Nothing in it is confrontational or testimonial in that matter. They're not preparing it for the purpose of trial. It's essentially
in other words, it's a business record,
It is
prepared
a
in the
business
ordinary
record.
course and not for trial.
Exactly. And in that context, all they have to do is produce a certified copy that the defendant is not indeed licensed to carry a firearm or does not have an FID card to possess a firearm. And it'll be as simple as that. So I would suggest to the court that the holdings in Powell does not jive with what the Supreme Court is suggesting that we do. We can't have it both ways. It either has to be an element of the crime that the Commonwealth has the burden of proof, which is fine the way the statute reads, and in this particular case that I'm before the court, the Commonwealth did not prove, therefore there was insufficient evidence, or if this court is saying, as it said in Powell, it is not an element of the crime, then the statute in its face is unconstitutional because you can't criminalize what is protected by our Second Amendment.
Well, if it's unconstitutional and your client has prior felonies, correct?
Correct.
So how does he, I'm just wondering about his standing to raise it, where you say...
The standing is not reached in this case, Your Honor, because we are not suggesting unconstitutionality of the licensing scheme, which was raised in Powell, or load hold. We're not saying anything about the licensing scheme, whether or not it's constitutional or unconstitutional. I'm not raising in this case. I suggest to the court perhaps a licensing scheme would be constitutional because in Heller it suggests that felons or people with mental illness can't carry.
You're saying that a crime of pure possession of a firearm is unconstitutional.
Correct, Your Honor.
Okay.
Yes. And I would suggest that the holding recently in Johnson and in load hold did not address this particular issue. In both of those cases, this court held it either waived or that it was not properly before the court, and that distinguishes from this case that we have before the court today, and that in this context, it has been raised, and the question is distinctly different than what has been decided by this court in the past.
Doesn't load hold deal with the carrying statute?
Load hold does deal with carrying statute, but in particular...
Say that the facial challenge to it failed?
No, Your Honor. What is said in load hold that essentially challenged the licensing scheme. They essentially said the fact that a prior governmental agency has to okay your right to carry a firearm is unconstitutional. That's not what I'm raising here. I am not raising the constitutionality or unconstitutionality of the licensing scheme.
So if the Commonwealth charges someone with unlicensed carrying of a firearm, you're saying that the Commonwealth has to prove that the person does not have a license?
Correct, Your Honor.
But what about the other exemptions? Can the Commonwealth rely on the defendant to produce evidence of other exemptions?
Yes, Your Honor, they could, because the other exemptions, unlike the license, is enumerated in a distinctly separate paragraph by the legislature at the end of the statute. So it doesn't read as part of the crime. It essentially is a enumerated list of exemptions that come towards the end of the statute.
The license, one of them?
No, Your Honor. The license is part of the statute itself. So if you read the indictment, it will read carrying a firearm without a license.
But the statute?
The statute itself would read carrying a firearm without having the authority to do so. If you go to the end of the statute, there's a paragraph that enumerates the exemptions, as Your Honor is suggesting.
What page is the statute on in your addendum?
Should be.
Is it 51?
But there's more to that statute than that, isn't there?
It is, Your Honor. That is the first paragraph of the statute that applies to the crime itself, and that's part of the indictment as it reads. So it reads, whoever except as provided or exempted by the statute, knowingly in possession, has under control a firearm.
This doesn't even tell you anything because it doesn't say it's a crime. I mean, don't we need more than that?
I apologize, the entire statute is not quoted here, but if you refer to the entire statute, the last paragraph, I'm looking at my sister's.
Yes, well, all right, that's where I am. It's in the red brief.
Okay.
At addendum 5 and on to 6. So what you quote is, I'm not sure what you quoted, actually.
My sister has it on addendum 9, and for the first paragraph, it reads, whoever
Are
owns,
we looking at
possesses.
10A?
It's 10H here.
Oh, H, okay, I'm
I
sorry.
don't see the, 10A is here as well, I'm sorry. It's addendum 5 is 10A. Looking
On
at
page addendum 5,
addendum 5, yes. As I read it, it all talks about carrying a firearm without a license, one, not being a place of residence, in effect, license to carry firearm under provisions, 1, 2, 3, 4, there was 5,
5 and then 6 subparts.
and then 6 subparts.
So you're saying the Commonwealth would have to, you can draw a distinction between licenses and the rest of these exemptions?
Well, I believe most of these exemptions, most of these that are enumerated goes to the licensing. The exemptions that I'm referring to are the exemptions that are for federal employees, there is one paragraph that is at the end of the statute that specifically lists federal government employee, police officers, other exemptions, and I'm referring to those exemptions, that those would be affirmative defenses that the Commonwealth does not have to prove, in opposed to unlicensed carrying of a firearm. The Commonwealth does have to prove it as an element. But again, if this court were to hold, as it held in Powell, that no, that is not an element, then the crime in itself cannot be criminalized, as it is under the statute, because it's protected act. So it cannot be criminalized. And I would like to just briefly touch on the other 2 issues as far as the motion to suppress is concerned, and the constructive possession, the insufficiency of constructive possession in itself. As far as the motion to suppress is concerned, I would suggest to the court that was insufficient probable cause for the search of the motor vehicle. Now, I concede that the fact that the defendant was involved in this assault and battery gave the police officers enough probable cause to arrest the defendant. However, the search that ensued of the motor vehicle, which then discovered the firearm, was not permissible and was unconstitutional. And I would say to this court that the stop itself, the underlying situation that precipitated this stop, was the assault and battery. The 2 other information that they rely upon for the search of a car and essentially looking for this gun was this informant, actually unnamed informant that was not even known to the police officer, that called the police department and said, I know this defendant was just released and he has a gun. We can't rely on that because that's essentially unreliable informant tip. The police officer doesn't even know the identity of the informant, and that's part of the record, and he testified to that. The other statement that they rely upon is the father of the victim's statement that told the police officer on the scene that this defendant is known to carry a firearm.
What about the person who tried to intervene and the defendant said essentially, back off, I have a gun and I'll shoot you?
He never says, I have a gun. He essentially says, quote unquote, back off or I'll cap you, which then he interpreted as saying, I will shoot you. He never said, I have a gun. He just says, back off or I'll shoot you.
So
now,
is it not a reasonable inference that capping somebody means shooting them?
Granted, even if he said back off and I'll shoot you, it's still not enough where he is confronted with this large male that by his own testimony had 5 or 6 beers before he approached the defendant and was overpowering, and it was simply self-preservation saying back off or I'll shoot you, because at that moment somebody coming at him, it would just be a defensive mechanism just saying back off or I'll cap you or I'll shoot you. In itself is not enough.
So the police are to disregard information that the defendant or that the suspect himself has told somebody that he may shoot them or may cap them?
Even if we follow that logic and say the defendant must have had a firearm on him, once they arrested him, they took him out of the car, they pat frisked him, and then they searched the area surrounding him, which he was up front in the passenger seat. There was no firearm found. There is no other reason to be looking for that firearm in the trunk in the back.
What about the automobile exception?
The automobile exception, I would suggest, doesn't apply to this case because the owner of the vehicle was present at the scene, and the car was not registered to my client.
I'm talking about the automobile exception. You don't need a warrant if you've got probable cause to believe that there's evidence of a crime in a car that is mobile.
But the evidence of the crime here is perhaps bloodied shirt. It was assault and battery. It was a bloody assault and battery. Why would
bag?
The bag had no involvement in the underlying crime itself. He's carrying a woman's handbag, and he leaves it by the side of the car by a woman. So the bag plays no role in the underlying crime, and the fact that this instrumentality of this particular crime, which is assault and battery, would be found in a car. If anything, it would be on his person or the area surrounding him, being blood transfer or what have you.
Where he has just threatened to cap someone in the course of this assault and battery, and they track the car down, and he's seen carrying a bag out to the car.
Which he leaves.
It goes back into the house, then comes back out.
Yes, and the bag is then carried by a female to a trunk of a car.
Put in the trunk of the car.
And closed, and the female
But
is
it's
the driver.
his bag. But it's his bag.
Well, there is a testimony that he was seen with the bag, that it belongs to his cousin, but that he had the bag, not that it's his bag. By all accounts, it's a female handbag. I see that I'm running out of time, and I will rely on my brief. Thank you.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. Just to address very briefly some factual issues raised by the suppression argument, I would just like to note that there are some differences in evidence between the trial and the suppression hearing. The evidence that Mr. Sylvia, when witness Mr. Sylvia runs over and tells the defendant to stop stomping on the victim, and the testimony at the suppression hearing was that the defendant then said that he had a gun and would shoot him. That the quote that I'll cap you was from Mr. Sylvia at trial, as was all the evidence about the alcohol. None of that was before the suppression judge.
Was there evidence that the man that came forward and said stop beating on the victim, that he knew of the defendant's reputation for carrying a gun?
I don't believe there's any evidence that he knew anything about the defendant or the victim.
Okay.
And on the other hand, there was considerable evidence that the police officers, a number of them had responded to domestic assault and batteries involving the defendant. I don't know how many of them were overlapping, but I think there would have been at least 6. One officer was involved in a shooting case with the defendant. Another officer, Detective Cabral, said that he had received a call, he received an admittedly anonymous tip saying Damien Gouse is out of prison in Massachusetts. He is carrying a gun again. And then he called the Rhode Island police, and they confirmed that the defendant had just recently been arrested on drug and gun charges. This was within 2 days of this event. And at that point, the victim's father says he's usually carrying. The defendant says, I have a gun. The officer, this is somebody who has frequently in the past had a gun. And that he is, in fact, the officer who orders the search of the car. And I think he advances even a number of different grounds, one of which actually, which is not, I believe, raised by anybody, but he essentially says, I would not let anybody get back in that car while I believe there was a gun in it, which also brings in even a Terry reasonable suspicion level of analysis that he thought that there was plainly a safety issue, that it was likely that I would infer that if the defendant did not have the gun on him, that would not preclude his having the gun accessible in the car.
So what is the basis of the search of the trunk? So the judge is talking about an inventory search.
Yeah.
I don't know where that goes. That's kind of interesting, but
Well,
different.
there are a number of different In terms of the inventory search, everyone in the car was handcuffed and taken to the station. Only the defendant was arrested. The two women were interviewed and subsequently were allowed to go. Detective Cabral, who authorized the search, said that he essentially wouldn't know, he felt he wouldn't know what would happen with them until after they had been interviewed. There was some reason to believe that they'd been sort of keeping surveillance for the defendant and were helping him drive away after he just committed a crime.
Was there some thought given also, or at least expressed, that the car may contain the victim's blood?
I believe
and that would be evidence of the crime?
I believe that was an idea advanced by the motion judge himself, that because it was a bloody assault, the defendant had blood on him, that there would be some evidence of blood in the car. He doesn't explain how it would get in the trunk, but I suppose if it's in the car somewhere, it might be subtle. If they had to tow the car to do the forensic search, you would be entitled to, you would have to do the inventory search on the entire car in order to tow it to search at further length for the probable cause of blood. So that would be another ground. Since there was nobody, they were all handcuffed. There was nobody available to drive the car. The car was parked on a hill on a street in the lane of travel. They couldn't leave it there.
What was the basis on handcuffing and arresting, I guess, the owner of the car?
It's not specifically clear. The officer essentially, what Detective Cabral seems to represent is that until they investigated further, they didn't know whether they'd had greater involvement in this. I don't know specifically what the theory was. I mean, it seems to me plausibly they could have been accessories after the fact to a certain extent. They were seen, they come out of the house, they're looking around, then the defendant comes out. They're taking him.
Even you would say that whether they were properly arrested or not, he doesn't have standing to raise that as a defense to.
Essentially,
to this, at least the inventory search part of this.
And in addition, just the fact that the fact is that they were not available to drive the car. The ultimate fact is that there's a car in the street.
Did the police know before they seized the car that two women were involved in transportation and placing of a bag in the trunk of the car?
Yes, they saw it happen.
Oh, okay. All right.
And they saw the defendant carry it out. He puts it down. The other woman puts it in the trunk. They're aware that she's the owner of the car because that's how they came to the address. The defendant had driven the car to chase the victim down and beat her up. And so then a witness got the license plate. They chased the license plate to that address, and they set up surveillance of that address.
So you're not arguing that there was probable cause to search for a gun?
I am arguing also that there was probable cause to search for a gun. This was only within 22 minutes of the original assault. The defendant had just said he had a gun. There was strong evidence based on the defendant's background and the officer's personal experience of the defendants to believe that he had carried a gun in the past, was frequently known to carry a gun.
And I take it there would be strong evidence that he wouldn't have a license.
Yes, the officer, at least one of the officers testified that he was not eligible for a license. He could not have had a license. I believe he had a number of challenges that would have rendered him ineligible, and the police were aware.
But they knew that. I mean,
they knew that at the time. Yeah. So there was no doubt about that.
But the primary basis to seize the car was that it was in traffic, it had been stopped in traffic, it was blocking traffic, and all the occupants had been removed.
There are different arguments. Different officers, I believe, advanced different theories of why it was done. But it ultimately, all the people were arrested. It had to be moved. I mean, I don't know if there was a discretion to do something else at that point.
The judge sort of treated a bunch of them somewhat equally.
Right.
Yes. And as I noted, if they had not arrested the passengers, the officer who ordered the search of the car said, he would not have let them get back in the car while he thought there might still be a gun in there for safety reasons, and essentially said, suppress the gun if you have to. I wouldn't do it. And so there's sort of a Terry logic there that the judge does not really investigate, but that would involve the reasonable suspicion standard, which I think certainly based on the background with the defendant, the fact that he just said he had a gun. Now, if I were trying to evade police, I might ditch my gun, but this is somebody who chased somebody down the street and beat them up in broad daylight in a residential area. The evidence suggests he doesn't think in that sort of purposeful way about trying to cover his tracks.
But the gun was found in the trunk, wasn't it?
The gun was found in the trunk.
So a Terry protective search doesn't generally include the trunk.
Well, if you put the passengers back in the car as the police drive off, there is a case don't know if I have it right here, where essentially the defendant's friends were getting back in the car, and they said, the police are not required to give them the opportunity to take whatever guns may be in the car and attack the police as they're leaving. That when it's associates of the defendant, in the trunk, that they could have gotten in the trunk either through the trunk itself or through the back seat of the car, assuming that they are in fact in cahoots with the defendant in some way, which they appear to be due that they seem to be aware that there's a need to be a lookout for the defendant, that it would be a danger to let them have his gun either. And on the subject of the question of whether being licensed is an element, I would argue, obviously there have been many, the issue's been extensively discussed today. I would just add that essentially this is not a new issue, that the cases that they're discussed in Gonzalez versus Dickhout, the whole Couture versus Jones. Couture was decided in 1990. And this court, I argue in my brief, made a very reasonable distinction there that you can't go up to somebody and start frisking them on the street because they have a gun by itself, but by the time of trial is a different matter. By that point, sort of the dust has settled, and requiring the defendant to produce his license at that time is not essentially isn't.
But the charge seems to be unlicensed carrying of a gun. We tell police officers that it's not enough just to see someone with a gun. That you can't arrest them for that. You also have to have some reason to believe that they don't have a license. So, is it or isn't it an element of the offense? But I think the question that I really want to help you, or to ask your assistance on is, if we were to say that the Commonwealth must prove in its case in chief that the defendant is unlicensed, is that workable vis-a-vis these other exceptions? It may very well be that it's not going to be that hard to introduce a business record from the Central Registry saying that the defendant does not have a gun, or have a license. But what about these other exceptions? How do we treat them? Is it workable?
I think that it would be. I don't know if it's unworkable in theory. I think in the nature of Section 10, it might very well be unworkable in practice. That there's a lot. It's a very complicated statute, and trying to figure out all the sections that don't apply to each defendant could very easily confuse the jury.
If he's charged,
if not the prosecutor and the defense counsel and the judge.
But if the charge is, in fact, unlicensed carrying of a gun, does the only thing the Commonwealth have to prove, other than the gun in carrying, is that that he has no license? Why should they also have to prove that all those other exemptions don't apply if the charge is unlicensed carrying of a gun?
Well, the title is essentially unlicensed carrying of a gun. It's not. It is true that is what differentiates it. It is true that there's no. The title of murder is not committing murder while possessing the mens rea. However, it's not murder if it doesn't have that. You call that manslaughter or innocent or something else. We don't phrase it that way, but we could. So I think that part of it is essentially a matter of drafting, that we tend to think of it that way. Just another thought that occurred to me on the issue of the difficulty of presenting this. I don't know how this would fit in exactly, but essentially in this case, the best way to prove that the defendant is unlicensed is to show that he is incapable of becoming licensed. However, that would prejudice him considerably in front of the jury. So in a case where, the Commonwealth, for whatever reason, was unable to produce the FID card, we might be put in a sort of difficult situation of, they have this alternate proof, but it's explosive.
Well, what if he had the license before he committed the felonies? Do they?
I suppose that it would depend whether that was before or after he committed the crime. I don't know what happens to your license once you've committed. I don't know if it goes up in smoke as soon as you commit the felony, or you're just unable to renew it. I don't know. So that could provide a sort of a difficulty with respect to the registry. At what point did his license become revoked? Does he have to know? Is it when he's that essentially there could actually be a number of different ways in which that could become complicated paperwork, whereas I mean, in this case, the simplest proof is that there is absolutely no way he could have been licensed at that time based on his prior convictions that predate this offense. So, and that's admissible, but not salutary to admit. There is also, I don't know, in this particular case, the jury actually did find that those prior offenses had been committed in the subsequent proceeding, which was not the same trial. It was before the same jury 4 days in a row. I don't know if there'd be some way to do that, but I think it might get quite complicated when it was delved into. There, no further questions?
Thank you.
Thank you, Your Honor.
Take a brief recess.
All right, please, we stand.
The trial court is an SPDP petition where the petitioner brings the case. So the Commonwealth is the, well, yes. Yes. Petitioner appellant. Of course. Okay. Yes. You're good. Do you know why two of the justices are recusing themselves? Is because they were on the... That's fine. Okay. Thank you. How much time do we have about?